All right, let's try this again. All right, so hopefully this is going to work. We were talking about freedom of the press. I told you freedom of the press is essential to a democracy because people got to be well informed. There are instances in which freedom of the press will be denied, although there's a very, very strict scrutiny. That's the actual term, which just means that there's a very, very high standard that the government must obtain in order to prevent the press from publishing something. And usually it's an issue of national security. Hillary the movie is ultimately what becomes the Citizens United case, but we're going to talk about free speech here. And so first, free speech pertains to political speech. Political speech is is protected again by the concept of strict scrutiny. So the government, if they're going to limit it, they have to have absolute grounds. It's a very difficult threshold for the government to obtain. We're allowed to criticize our government, right? So just expressing political ideas is not something that is impermissible. And protests and things like that are a part of political speech as well. Where political speech or where speech really is sort of limited is when there's immediate harm. So if there's an instance in which somebody is sort of compelled to engage in some behavior that is dangerous, that would be an issue. Brandenburg versus Ohio is a court case that basically says that speech is permissible even if it's subversive, so long as it's not an imminent call for action, and it is believable that action would actually be undertaken, right? If a homeless guy is like, "Hey, overthrow the government," right? And he's out there wearing a little tinfoil hat, like, he's just crazy. Like, that's, believe it or not, that's actually sort of protected speech because he's crazy. And there's no belief that anyone would actually engage in the behaviors in which he's advocating for. Citizens United, again, this is a Supreme Court case that just overturns sort of campaign finance limits. So money is the equivalent of free speech, right? So if you're Mike Bloomberg and you've got $60-some billion and you want to drop $600 million on your ill-fated presidential campaign, you're more than welcome to do that. Expressive speech, so this would be offensive or obscene speech or fighting words. For the most part, there's not a lot of public interest in allowing for lewd or obscene speech. A lot of the times that can actually be limited. The fighting words, on the other hand, again, unless it's sort of that same concept of imminent threat or an imminent danger, for the most part, that's allowable as well. Hate speech or offensive speech is actually protected under the First Amendment. It's actually a part of our political expression. So you won't go join the KKK and espouse all that hate and the obscenities that they believe in. Like those are protected words. I mean, we can all think that they're reprehensible and terrible and awful, but the fact of the matter is that in our system, they are absolutely permitted to express their political ideals and their political opinions. And if they believe that only I don't even know what the KKK believes, that white Anglo Protestants, maybe is white and Anglos, I don't know, that might even be redundant. I have no idea. Some important cases about this. So there are some instances in which we have tried to limit some hate speech, limit speech. This is actually something that's becoming more prominent today with things like safe spaces on college campuses. But just understand that for the most part, if you're going to ban speech or if you're going to ban one organization, it has to be sort of a blanketed across the board, right? And so a decent example of this is there's a case, and I forget the name of the case now, Kid got suspended for wearing a T-shirt that said Edwards, John Edwards, right? It was John Edwards who was running for president in 2004. Right, and the school had a policy of no writing on T-shirts. Like that was part of their dress code, and dress code would be expressive speech. And so the kid got suspended for it, not because the shirt was obscene or whatever, but because it was banned across the board. And so long as it's neutral in sort of its content, there are instances in which speech can be banned in that regard. Student speech, you don't really have free speech. In fact, Morris v. Frederick is probably the best example because a kid like held a big old sign that said "Bong hits for Jesus," and as you can imagine, he got suspended. And for the most part, as a student, you're going to have fewer rights than regular people. Commercial speech is not nearly as protected as political speech. So, for instance, there's all sorts of regulations or limitations to what can be done commercially. You can't sort of blatantly lie in an advertisement and be like, these Oreos are fat-free, because we all know if the Oreos taste good, they ain't fat-free, right? Take it from a fat kid. Like if you're the virtual, like, yeah, I'm a big dude. But the fact of the matter is that you can't blatantly lie in your advertisement, in your commercial speech. There are actually thresholds that you have to meet if you want to claim something as low calorie or low fat or reduced fat or whatever. So there's a little bit more regulation in that regard. Okay, symbolic speech would be things that are that would be protected under the rights of speech and petition and assembly and maybe even press. If you had like a picket sign, like it's obviously something that's written there as you're protesting, as you're assembling. Again, it's free speech if it's in public places. Symbolic speech is generally allowed. Symbolic speech would even be things like Texas versus Johnson and the burning of the American flag. That's absolutely permissible. Print media, so freedom of the press. We talked about that a little bit already. There are some limitations, so they can't be reckless in the disregard of the truth. There are some expectations that they are factual and honest. They also can't engage in libel and slander, although that's a little bit of a slippery slope, simply because the threshold for proving injury from libel or slander is very, very hard to meet. And so, you know, if you were to just post online, go on Twitter or wherever and be like, Baker is the worst teacher ever, right? Like, yeah, you're slandering me. It's liable. Like it's negative toward me. But there's ultimately no real injury that I can prove. So, I mean, if you say that I don't know anything, or I mean, that's just an opinion that you're entitled to. Pornography is actually really difficult to even sort of determine what it is. There was a justice, it's the quote down there at the very bottom from Potter Stewart, who said that basically you can't define pornography, but he knows it when he sees it. And the reality is that at this point, sort of pornography has now changed. And so the idea is it in violation of community standards? Is it, offensive in its very nature? But then the real sort of key down there at the bottom, number 3, does it lack value? And that value is literary, artistic, political, or scientific, right? So for instance, if you look at like a scientific textbook, and I don't know what's in textbooks, right? But if you had a biology textbook or a textbook that had images of STIs, and therefore obviously with sexually transmitted infections, you have if you had images of those diseases, those might be like pornographic, but there's obviously scientific value to that. Artistic or literary value, like that's a little bit harder to sort of differentiate. There's a book called Lolita by Vladimir Nabokov, which I personally would argue is sort of pornographic. It's disturbing, but it's deemed to have literary value, and so it's generally deemed to be protected. Second Amendment, the right to bear arms. You're allowed to own a gun. I do need you to understand that this, just like others, is not unlimited. In fact, if you really think about it, the right to bear arms, that's the actual verbiage in the Second Amendment. There's more to it than that, but that is the verbiage. Arms is simply another sort of synonym for weapons or munitions. You probably learned in a U.S. history class about the nuclear arms race. So nuclear weapons are nuclear arms. You have the right to bear arms. Do you have the right to own a nuke? And the answer is certainly no. No, you do not, nor should you. The DC v. Heller and McDonald versus Chicago are the two big cases about this and about whether or not you have the right to own a gun. Rights of criminally accused. So one, in the event that you are accused of a crime, due process of law has to occur. And due process is a term that you'll actually hear throughout this unit relatively frequently. Basically, due process, again, this is one of those sort of things that the term can be defined with the words in it. It is a process, meaning it is a procedural, like step-by-step thing that an individual is due or owed prior to having their liberty taken. And so the 4th, 5th, 6th, and 8th Amendments basically all work together in due process of the law for criminally accused individuals, right? You're protected against unreasonable searches and seizures, cruel and unusual punishment, this, that, and the other. So the 4th Amendment is protection against the illegal searches and seizures. The government cannot come and just take your stuff. They cannot just come and search your stuff. If they do so illegally, the evidence that they obtain is not permissible. But we have had a little bit of a reversal on that over the course of time. So with the exclusionary rule, meaning that if the evidence is obtained illegally, it gets thrown out. Sometimes judges will say that it's inevitable discovery, and if the discovery was quote unquote inevitable, then it's back in. United States versus Grubbs there in 2006, it's the courts allowing for anticipatory warrants, right? So they don't even have a warrant yet. And so these are some of those issues that are highly sort of controversial as it pertains to the 4th Amendment today. 5th Amendment, right? You right protection against self-incrimination, right to a grand jury. There's a couple of other things in the 5th, but as it goes to the rights of the accused, those are the two big ones, right? Like you don't have to talk, you don't have to incriminate yourself. And a grand jury does have to determine whether or not you're going to be put on trial, which is a basic protection that you probably wouldn't think is necessary. But, you know, if you lived next door to like the prosecutor and you had some sort of dispute, like your dog kept pooping on his lawn, you know, you would hate it if he could just use his sort of position in life to keep bringing charges against you and keep bringing you into court and forcing you to take time off, all because your dog keeps pooping on his lawn. And it makes you a terrible neighbor, but you shouldn't go to jail for it. So grand juries are important in that regard. The right against protection against double jeopardy. You can't be tried twice for the same crime. Understand, I used to teach this in the ghetto, and kids were like, yeah, I can rob a liquor store and then I'll go to jail and then I'll get out and then I'll rob the liquor store again and then they can't prosecute me because it's the same crime. No, that's a different crime. Just because you're dumb enough to rob the same liquor store twice doesn't make it a new crime. There are also some issues with double jeopardy, though, because we do have two sort of sets of law. We have state law and we have federal law. And so there are some instances in which federal law can, where you could possibly be tried both by the national government and by the state governments. 6th Amendment is a right to trial by jury quickly. They have speedy trial, and you're allowed to have an attorney. Gideon versus Wainwright is what incorporates that concept. So now, if you're tried at a state level, the state government must give you an attorney as well. Even if you can't afford it, they'll provide one for you. In some states, those public attorneys are actually full-time employees of the states. In others, they're hired out or they're contracted. Two of my friends in California are public defenders. They're actually they are contracted out by the county that they live in. They work at a law firm that has that contract. The Eighth Amendment protects against cruel and unusual punishments, but it also protects against excessive bail. So if you get caught, I don't know, let's just say robbing a liquor store for $300, because there's a threshold. I think it has to be $250. It might be $500 now. But let's just say you just barely go over that threshold, and it's a first-time offense, and you didn't even use like a gun, right? Like maybe the clerk was just dumb enough to walk away and leave the cash register open, and so you just grabbed the cash and ran. $1 million bail obviously would not be appropriate in that instance. That would be an excessive bail. Again, you couldn't be fined $1 million for stealing $500 either. That would be an excessive fine as well. Those are things that you have protections from. Right to privacy. This is actually not explicitly in the Constitution, but it is incredibly important because as society has gotten increasingly complex, right to privacy has crept up more and more and more, whether it is through your ability to get birth control, because there were instances, Margaret Sanger, you may have learned about her in a U.S. history class, that was actually in violation of federal law by mailing women birth control. Roe versus Wade is really a right to privacy issue. Abortion is about privacy, not about murdering babies. Sexual orientation. Bowers v. Hardwick. I think it's Bowers v. Hardwick. Whether or not you're protected in the private behaviors that you engage on in the privacy of your own home. And now right to die is coming into that. So you have some states that are allowing for sort of physician-assisted suicide, that it's your life, it's your privacy. If you are terminally ill and you want to end it, should you be allowed to do that? Is that permissible? Roe versus Wade is obviously our abortion case. It's incredibly complex and nuanced in terms of how the decision was actually reached. We won't spend a ton of time going through it in great detail, but obviously we know that it's a contentious topic even today. Amy Coney Barrett is currently in the midst of her confirmation hearings, and this is something that she is probably going to be required to address in at least some manner. I'm going to click through the rest of these sort of slowly, just in case there are some things that you want to look at. Because some of these statistics are actually really interesting. They're worth knowing or understanding or being aware of. And so if you want to pause these, obviously you're more than welcome to. All right, so that takes us to the end of what we need to know. There are some other issues. Hobby Lobby, if you want to really get into freedom of religion in detail, but the great thing is your essay for this unit is going to be writing a dissenting opinion for the Supreme Court. So you're going to have an opportunity to look at a wide variety of cases and figure out what you think is appropriate for the Supreme Court. And the Supreme Court deals predominantly with civil rights and civil liberties and constitutional issues of that nature. So if you need help with that, let me know. But we'll deal with that, or we'll talk about that when it comes to it. All right.